Hello everyone and welcome to Tatev Talks Law. This series is being produced in collaboration with the International Law Society at Penn State Dickinson Law to build a bridge between US and European, including Armenian legal communities, by sharing practical insights into how different legal systems operate. My name is Tatev. I am a Fulbright scholar and a law student at Penn State Dickinson Law, and through this podcast I wanted to create a space to explore law from a comparative perspective and learn directly from legal professionals. I am also joined today by Brendan Lay, the president of the International Law Society of Penn State Dickinson Law, who will be co-hosting this episode with me. In today's episode, we will be discussing civil and criminal procedure, jury trials, and broader questions around fairness and the death penalty from a comparative perspective. I'm really pleased to be joined by Professor Brent Newton. Professor Newton holds a JD from Columbia Law School and has had an extensive career in criminal law, including serving as a federal public defender, working with the U.S. Sentencing Commission, and representing defendants in complex federal cases. He also has significant experience with death penalty cases and appellate litigation, and has taught widely and published extensively in these areas. He has taught over 100 law courses at institutions including Penn State Dickinson Law and Georgetown, and has authored several books and numerous publications on criminal procedure and sentencing. He is also a member of the American Law Institute. And on a personal note, I had the opportunity to take civil procedure in my first semester, and I remember being genuinely impressed by his teaching style, his enthusiasm, and his overall approach. Something I definitely hope to carry with me in my own teaching in the future. Professor Newton, thank you so much for joining us. It's a real pleasure to have you here. So to start, in civil law systems like Armenia, the procedure is more judge-driven, whereas the US system is more adversarial. From your perspective, how do all these differences affect fairness and efficiency in practice?
That's a great question, and good morning, and thank you for having me. I used to teach a course, undergraduate course, called Comparative Justice that compared the US legal system, in criminal cases in particular, to many countries throughout the world. Not all the countries, but representative countries: Russia, China, Argentina, South Africa, Japan, China, Saudi Arabia, Iran, Turkey. So the vast majority of the rest of the world does not do what we do in the United States, which comes from our British origins. We do the adversarial system, and we do it more than even the British do it. So majority of the world does the continental European model, the Germanic and the French, model, which extended to Asia and South America and other places. There are pros and cons of both. The pro of the American system is you have a dedicated attorney who is fighting for you regardless of your guilt. The government has the burden to prove, the prosecution has the burden to prove beyond a reasonable doubt each and every element of the charge. It's not guilty versus innocent, it's guilty versus not guilty. And there are a host of very important protections for a defendant. Now, the continental model is judge-driven. Magistrate judge, and by the way, the term magistrate in the United States refers to a low-level judge, and not necessarily it's not meant to be an insulting term. I don't mean that. It's just generally magistrate is a lower-level judge in relation to other judges, district judges, circuit judges, whatever. Continental system, magistrate is an important judge, higher-level judge, and in fact, the continental system uses magistrates on their feet, so to speak, right? The judges get out there and do investigation, talk to witnesses. They run the proceedings. I mean, yes, they're defense lawyers and prosecutors, but the judges are not passive, they're active traditionally. Now we're seeing changes around the world where there's a mixture of adversarial and continental model, but the pure continental model still is dominant in a lot of places. Lawyers are less important, the magistrates are more important, and their goal is to get to the truth. They are not going to let the adversarial protections get in the way, so to speak, that they do here. Don't get me wrong. I'm not saying either system's perfect. They both have their pros and their cons. They're just functions of history, right? The British system was this weird system that grew out of the feudal times and the class system, just happened to grow out. It's not divinely ordained. It just happened to grow out of the British system and spread to the rest of the continental or the Commonwealth countries, including the United States. Conversely, what happened in continental Europe also was a function of its unique history. So neither of these were designed well. They just grew out of their cultures and their histories. They both operate in ways that have pros and cons. Some people would say the American adversarial system is ridiculous because it does not look for the truth. It allows criminal defense lawyers to obstruct the truth. I'll give you an example. And I can't get into any specific cases because of the attorney-client privilege and the duty of confidentiality and all that, but I can tell you, I have had cases, and I've seen many of my defense lawyer colleagues have cases, where we knew good and well our client was guilty as could be. The client wanted to have a trial, that's their right, and the adversarial system, that's their right. They get to choose that. Now, they didn't testify, and we cross-examined witnesses, we the defense lawyers, we knew they were telling the truth, right? But we cross-examined them with legitimate reasons to cross-examine them, prior criminal records, plea bargains with the government, statements they've given in the past that have some inconsistencies, which always happens because, you never say exactly the same thing when you tell the story a second or third time. And our whole goal is to raise a reasonable doubt. Doesn't mean they're innocent, right? It's simply raising a reasonable doubt about whether the prosecution has proved each and every element of the charges beyond a reasonable doubt. Some people would think, including my family members, sometimes who've watched me in court, wow, that's not cool. You're helping a guilty person go free. And my response is, no, I'm not. I'm doing what our constitutional system is designed for, with the right to counsel, the right to confront witnesses, the right to subpoena my own witnesses, and simply to raise a reasonable doubt. There's nothing, in fact, I would be unethical and I would be providing ineffective assistance of counsel if I did not do those things within the bounds of ethics, right? There's some continental European or people who have the same model around the world who hear that and they're like, that's absurd. That's not how our system's supposed to work. It's not supposed to let guilty people go free because tricky lawyers know technicalities, right? That's the way they view it. Conversely, we view their system. What are the judges doing out talking to witnesses? People who've, the only exposure the vast majority of Americans have to the continental system is Amanda Knox's case in Italy, right? And the criticism of the judge who was browbeating witnesses or whatever. I mean, and we portray it on our Netflix documentary as some horrible, injustice. And I'm not suggesting anything about Amanda Knox being guilty or not. That's not my point. I honestly don't even know the facts of her case very well. I'm just repeating what I've heard people say about that magistrate in the Amanda Knox case who did all these things wrong in the beginning. That's simply our version. We're looking at it through our lens, and they look at our system through their lens, and they just are completely different systems. And they're functions of these things that grew out of, 1,000 years of history on the continent and in Britain.
This semester, one of the most striking differences for me was that the US system has a stronger emphasis on revealing the truth rather than continental Europe, where legal proceedings can be more strategic. In the US, you will be disciplined as an attorney if you prolong the legal proceeding just for your client's interest. Whereas in continental Europe, also in Armenia, it's allowed for attorneys, for lawyers to prolong the litigation or just to take some strategic actions for your client's interests. How do you see these differences affecting legal fairness or justice in general?
Well, first of all, your question is raising another point I need to get into, which is the difference between American criminal cases and American civil cases, right? American criminal cases are not designed to vindicate the innocent based on the truth, right? American criminal cases, and I'm talking about the U.S. constitutional provisions as well as all kinds of other provisions. The Confrontation Clause, the Compulsory Process Clause, the right to counsel, the right to silence, all those things are again, based upon this notion that a person's presumed innocent, even if they're really, really, really guilty, and the American system allows good defense lawyers to raise reasonable doubt even if they know their client's guilty. That's not getting to the truth. That's not designed to get to the truth. Conversely, American civil cases where these things don't apply. We don't have the constitutional rights in the Bill of Rights, the Confrontation Clause, the Compulsory Process Clause, the right to counsel, the right to a jury. Well, you have a right to a jury in a civil case, but all these other rights do not apply in civil cases. Instead, the federal rules of civil procedure and the states that have adopted equivalent rules, many or most have, those are designed to getting to the truth, right? You get massive amounts of discovery in American civil cases. You get to depose witnesses, you get to depose the other party, you get to subpoena third-party witnesses, you get interrogatories, you get all these different kinds of massive amounts of discovery in American civil cases that get to the truth pretty quickly, or at least, well, I shouldn't say quickly, eventually could get to the truth. Conversely, you don't get those things in American criminal cases. We don't have nearly the pretrial discovery in American criminal cases that we do in civil cases. So your question is about civil cases. Now, in America, as I said, we do eventually get to the truth, I think, through discovery, in contrast to American criminal cases. So very important to draw that distinction. We do have a rule, ethically, that says you should not prolong litigation for the sake of prolonging litigation, i.e. forcing a settlement, which is typically what the goal of one of the both parties is. However, that rule is violated all the time. American civil lawyers all the time extend the proceedings in the hope of eventually settling. We wear the other side down because they can't afford the attorney's fees or the expert witness fees or whatever. So what happens in theory in America and what happens in practice in civil cases, very different things typically.
So ideally, if I got you correctly, ideally the attorneys, the lawyer, they would face some penalties. But in practice, they don't face any penalties.
In rare cases, a judge will find some lawyer was extending the case just for the sake of extending the case and not in the interest of justice. But proving that is a really difficult thing. And there's just a culture of not opposing further delays, and judges are busy and their caseloads are busy, and civil cases can just be protracted for years. So reality versus theory is important to, and that's true of anything in our legal system, right? We have all these grandiose ideas and rules that often just completely get ignored.
That's very interesting.
With the imprimatur, at least implicitly, of the court system at times.
So you talk about procedural rules. In Europe, the procedural rules are more codified than in the States. We kind of figure it out as we go, and eventually we have the act. How do you think that affect the predictability and, more importantly, access to justice here in America as opposed to Europe?
Great question. So we have a common law system, even though we now have, a multitude of statutes and procedural rules. Nonetheless, our system still gives judges an enormous amount of power in interpreting. In the old days, judges made all the law. The old common law system, there was very little statutory law, very little constitutional law. It was just judges making law. Today, judges have a lot of statutes they have to deal with and have a lot of rules, civil procedure, criminal procedure rules they have to deal with. But they still make law all the time. They interpret vague language. They fill in gaps, right? Statutes and rules don't answer everything the way they do in a civil code system.
It's also impossible to regulate everything.
You can't regulate everything by legislation in advance. So I honestly don't know enough about the civil code system and the way their system, and of course every country is going to differ to some degree. It just seems to me that you can't have a civil code that answers everything. Courts have to fill in gaps, and whether you want to call that common law approach or not, it's still what they're doing. I imagine. I can't imagine they're just, every civil code covers every single issue. No one can foresee everything.
But personally, do you think, Professor, that in the U.S. you have more flexibility than we have?
I understand from lawyers that I've talked to in civil code countries that judges have immense power compared to other countries, especially our Supreme Courts, state Supreme Court, federal Supreme Court. And that there is more flexibility to the extent that there are gaps, and judges are going to get to make decisions, and lawyers therefore may have a particular opportunity in a given case to get a judge to rule their way because the statute or the rule is not entirely clear about something. And that leads to division, by the way. We have massive division in our country all the time. One federal circuit court of appeals will interpret a statute this way, another one will interpret a statute that way, and there'll be division in the lower courts for years or decades before the U.S. Supreme Court can take it and resolve it. So we have a lot of disparity and uncertainty in our system because of our common law.
I would like also to touch upon a very interesting topic about jury trials. There have been some discussions in Armenia recently about introducing jury trials to Armenia's legal system. I know that trials is central to the US legal system, but it's absent in continental Europe in general. So what do you think are the main advantages and disadvantages of jury trials, and do you think it would work in smaller countries like Armenia or smaller legal systems?
Ooh, that's a tough question. So I have been a member of two different juries myself. As a lawyer and a law professor, I was selected to be on juries. And I really shouldn't say selected. The way we don't pick our juries, we strike people and whoever's left standing actually are. So it's really jury exclusion, not jury selection. But ultimately, I was on two juries. And
I remember all the interesting stories that you were telling during our lectures.
It taught me a huge amount about how the jury system works. I'd argued to juries many times, and then all of a sudden I'm on a jury, to a civil case and a criminal case. It's what we call a crapshoot, right? It's you don't really even know who's going to be on your jury. You can try to narrow it down to people you think are going to be good, but you don't get extensive background checks of just prospective jurors. It's a wild card. And so sometimes you'll get, depending on the party you represent, and it's true in a civil case or a criminal case, it depends on the party you represent, it's kind of just luck. And sometimes and all it takes is one juror to hang up you got to have unanimous verdicts, at least in criminal cases, and one juror hangs it up. And I mean, if I were designing a system from scratch, I would probably utilize juries. I probably wouldn't use them as much as we do here.
So if I got you correctly, you think that it would work even in smaller countries?
Under the right conditions, right? So some countries, like I think France and South Africa, they use lay assessors. So they kind of mix professional judges with jurors. I think that's an interesting idea because it lets the judges get the non-lawyer, non-professional's perspective on things. Again, there are a lot of values we have in this country, democratic values that go into our jury system, right? You get to vote, you get to run for office, and you get to be on a jury. Those are the things that make our country democratic, right? And being on a jury is a reflection of democracy. So sure, I mean, it sounds like a great thing, but it can be very dangerous if you don't have the qualified or appropriate people on a jury in terms of understanding things. But it also gets really tricky when you start trying to exclude people. Oh, you're not educated enough. That gets into class and can be a proxy for race and other things. So it's a very difficult issue. At the same time, I've had unelected, unaccountable federal judges, at least, who I think are terrible decision makers. They're biased. They have all the problems that I would see in a jury system, but perhaps, on steroids because they're just one person, right? They're making decisions about facts, for instance, where maybe they're making a fact finding about some important issue where they have never lived a life that would give them a perspective to make that fact finding. So there are problems in both systems. There are problems with judges being the fact finder, and there are problems with jurors being the fact finder. There needs to be a kind of a happy medium, and that's kind of why I'm very interested in this notion of lay assessors, which are three people or six people or however many who then sit with professional judges. They at least give the professional judges perspective.
Professor, that was actually something I would like to touch upon shortly. Do you think jury trials can enhance fairness, or the opposite, it will introduce some bias into the legal system?
Clearly, when you exclude people when you don't have a fair cross-section of the community, right? So in our country up until 1986, it was perfectly permissible to exclude people of color from juries, and we had mostly white juries, I mean almost all white juries throughout the country, until the Supreme Court in 1986 began a series of decisions that said you cannot exclude based upon race or ethnicity or gender. If you get a fair cross-section of the community, if you get people who care, if you get people who have sufficient education to understand legal concepts in jury instructions, I think it could be a good system. The problem is we don't often get those people, or we get people who don't reveal their real beliefs, because picking a jury takes a very brief amount of time, and people aren't going to reveal that. People are rarely honest during jury selection. They're not, and maybe they don't even realize they're biased, but they are. And until they acknowledge their biases, we don't have the ability to really pick a fair jury. So again, there are problems. There are problems in both systems, and it's definitely worth study, and there are plenty of countries that one could study that do no juries, lay assessors, juries in different ways, like England or UK. They pick juries very differently than we do. For instance, they let permanent residents be on their juries. Can you imagine in the United States letting a permanent resident, you have to be in, at least this was true when I visited Britain and studied this 15, 20 years ago. People who had been, I don't know what they call them, but what we call permanent residents, people who are non-citizens who live here permanently, indefinitely. If you had lived in the UK for 5 years and you were a permanent resident, you could be on a jury in the UK. Imagine that in this country. That would never happen.
Fox wouldn't like that. Now, I kind of want to circle back on the judge-driven as opposed to the adversarial system. How do you think this differences has developed protection for defendants in America? Because we've talked in program about a lot of Brady's claim, Kyle's claim. All of these come from prosecutorial misconduct.
Well, when you have a prosecutor who has absolute discretion, unfettered discretion to bring charges, and very strong, it's not unfettered, but strong discretion before trial about revealing evidence, because we don't have the same kind of discovery in civil cases and in criminal cases. Lots of prosecutors understand that the case won't get reversed on appeal or in a habeas corpus petition if they hold back certain evidence, unless that evidence is really, really important, which you have to prove, basically a reasonable probability the result of the case would have been different when a prosecutor fails to disclose evidence before trial. And this is the constitutional rule, not the ethical rule. That's a different issue. But that system, combined with the just absolute, pretty much unfettered discretion to bring criminal charges, gives an enormous amount of power to the prosecutor that in a civil inquisitorial system doesn't exist to the same degree. You have a judge who's kind of checking everything. I like that aspect. Again, there's a positive in that system. The negative is you've got a judge who can be too powerful. And if that judge is not ethical and competent and fair, that judge can run roughshod over a defendant's rights. A lot of our systems, whichever the country, it ultimately depends on how good the judge is and how fair the judge, the prosecutor, how good and honest they are, and how competent the defense lawyer. So a lot of this is a question of competence. I think in any system, if you had fair, competent people in all the different positions, the systems would work fine. But that begs the question, do we have honest, fair, competent people who play all these important roles? Judges, prosecutors, defense lawyers. I think that's very debatable.
Now, how do you think the discovery process in the criminal proceedings affect our right to a speedy trial, to move things along quickly? Because you say that in the criminal system, we don't have as much discovery.
Oh, very little discovery in American criminal cases compared to civil cases. A tiny fraction of the kind of discovery. You don't get depositions in American criminal cases, for instance. You don't get interrogatories in America, partly because the defendant has a constitutional right to be silent, but the defendant doesn't get to shoot interrogatories over to a prosecutor who has no right to be silent, right? So in terms of speedy trial in the United States, I mean, we have so many criminal cases, we don't have speedy trials, right? We have something in the neighborhood of 15 to 18 million criminal prosecutions in the United States every year. Most of them misdemeanors, and a lot of those small misdemeanors, but they're still criminal cases. So our courts are clogged. And we don't have a speedy trial because we have a clogged criminal system. We don't have speedy civil resolution because there is no right to a speedy civil trial. And there's even more of those civil cases that clog the court system. And that gets into a whole other question, which maybe is a different podcast down the road. Why do we have so many lawyers in the United States? And why does a lawyer not have to pay, or the party not have to pay the other side's attorney's fees in a civil case if they file a lawsuit and they lose?
Would like to turn to another more debated topic about death penalty. I know that many European countries, including Armenia, have abolished the death penalty while it remains in use in parts of the US. So, in your opinion, what are the main legal arguments for and against the death penalty?
Well, in the United States, and this is something that has been repeatedly relied upon by Justices Thomas and Scalia and others who have been, well, late Justice Scalia, justices who have been kind of the voices on the U.S. Supreme Court in favor of the death penalty, so to speak. I don't want to say in favor of the death penalty, but they're the ones who typically are arguing positions or making rulings when they're in the majority, or dissenting opinions when they're in the dissent, against the position of a death penalty defendant before the court. They point out correctly, our Constitution mentions the death penalty several times. It mentions it in the Fifth Amendment. You have a right to a grand jury in a capital or other infamous crime. 14th Amendment and the Fifth Amendment due process clauses, the right to due process of law before your life, liberty, or property is taken from you. Clearly, our Constitution envisions the death penalty. And if you go back and look in 1789, when the Constitution, in 1791, when the Bill of Rights were adopted, we had the death penalty for many, 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 many crimes. Theft, not just murder, robbery, kidnapping, sexual assault offenses. There was the death penalty for all that. Until 1972, most states used the death penalty for things like sexual assault and some other crimes not resulting in death. So it's beyond debate until we if we ever were to amend our Constitution, that it does not per se prohibit capital punishment. That said, how is it implemented? How fairly is it implemented? How constitutionally is it implemented? I could go on forever about the problems with the fundamental systemic unfairness in capital punishment. Not saying it's inherently unconstitutional as applied. Right to counsel, there are some just abysmal capital defense lawyers, even today, representing people who have no qualifications, no legitimate experience to be representing people who were charged with capital crimes. The prosecutors, because of limited discovery, even in death penalty cases, often do not turn over very important evidence to the defense. Juries, still today, people are being excluded because of race and class and other things that could affect the fairness of a jury. The number of people who are sentenced to death who have very, very compelling backgrounds in terms of mitigating evidence. Abused as children, seriously neglected as children, brain damage, intellectual disability, growing up in horrific circumstances that certainly isn't an excuse for killing somebody, but it certainly helps explain why they did what they did and mitigates their culpability, right? So there's all kinds of arguments that can be made about the fairness of the death penalty, even while recognizing it's not inherently unconstitutional.
Professor, I also wonder, how do all the concerns about wrongful conviction or unequal application affect the fairness and overall the legitimacy of the system?
I'll give you a good example, and I'm hardly suggesting the vast majority of people on death row are innocent of killing somebody. I think the vast majority of people who are on death row did kill people, right? That's not, though, an automatic death penalty. We have millions of murders, but only a tiny fraction of those people, I should say millions, we have probably tens of thousands of murders every year that add up to millions over time, and only a tiny fraction of those people. Our death row's got 2,000 people or something in the country, right? So it's like getting struck by lightning. That's what one of the justices in the famous Furman versus Georgia case said. It's unconstitutional, not because the death penalty is itself wrong, it's because it's like getting struck by lightning. It's arbitrary. There's still a lot of that arbitrariness today. But back to the point, the death penalty is if it were limited to the worst of the worst, I think very few people would have a problem with it, right? If it were the DC sniper, I don't know if y'all know who that was, or two people, but if it were the adult man who was the DC sniper, if it were Timothy McVeigh, the guy who blew up the Oklahoma City courthouse, if it were those kind of, or people who, some of the more serious offenses in the modern era, people who go in and mass murders in schools or whatever, if that's who they went after the death penalty against and didn't go after and all murders, of course, are horrific, don't get me wrong, but they didn't go after the person who killed people during a robbery of a store, or they didn't go after someone who, broke into a home and killed somebody or whatever. Or they didn't go after some drug dealer who killed another drug dealer, in the course of a drug deal. If they only went after the worst of the worst, I think the debate about the death penalty would go away. There'd still be a very small fraction of people who'd say it's inherently unconstitutional or inherently immoral. Problem is we have so many people who they go after the death penalty for, or we have in the last 30 or 40 years, who just are no different from 99% of other cases where they get life sentences. So it's just arbitrary. That's one of the problems.
Now, from your experiences, how does the standard of beyond a reasonable doubt, is that as high as people think it is, or is that just kind of, it varies between juries?
Well, in theory, it's very, very high. Right? I mean, when I teach the differences between preponderance of the evidence and proof beyond a reasonable doubt, I put preponderance, which we articulated, 50.1% or more certainty of a fact. I put proof beyond a reasonable doubt in the high 90%. And the Supreme Court said don't put a number on it, but everybody does. It should be a really demanding standard, but it's not defined in a lot of jurisdictions. The Supreme Court said you don't have to define reasonable doubt. Do you think the average person has a clue what it means if you don't define it? So you get people who convict, quote, beyond a reasonable doubt, but they don't know what it means. And they're really probably convicting based on this notion of is it more likely than not? And that's not proof beyond a reasonable doubt. Let me end with this one point. You ask about unlawful convictions and that being a problem with the death penalty. As I said, vast majority of people on death row, I think, did the crime. That's not the issue. But with respect to innocent people on death row, or people who, where there's a real doubt about their guilt, there are documented cases. I mean, DNA exonerations and other really powerful examples of real evidence exonerating or raising serious doubts about whether somebody actually did it. There shouldn't be one of those where somebody gets sentenced to death, because you can't get it back once they've been executed. So that's another, if I were designing a system, I would say proof beyond a reasonable doubt to be convicted of murder for purposes of eligibility for the death penalty, proof beyond all doubt, or at least proof beyond overwhelming doubt, or some variation of it that lets jurors have this almost near certainty, not just proof beyond a reasonable doubt, and define it in a meaningful way. So before anybody gets sentenced to death, you better have just overwhelming evidence they did it, as opposed to just having some jailhouse snitch who comes in and says he admitted he did it, and then maybe have a confession where the guy was intellectually disabled. I mean, there are just many documented cases of people who've been sentenced to death where the evidence was not. Maybe it was beyond a reasonable doubt, undefined, but it's not absolutely overwhelming evidence.
Incontrovertible proof, maybe?
Incontrovertible proof, however you want to define it.
Yeah.
Something more than just an undefined reasonable doubt standard.
Okay, awesome.
So another point I would like to turn to is your international UK experience. I know that you have worked with UK barristers in extradition cases. So what differences did you observe between US and UK legal systems, legal practices, and particularly in criminal matters?
So my exposure to the British system is, I've had several different kinds of exposure. I went to the UK as a lawyer for the first time in 1995, doing research in the Inns of Courts libraries. This is before the internet. On a capital case I was working on in the Supreme Court about delays in carrying out executions as being cruel and unusual punishment. The case was called Lackey, Texas versus Lackey, or Lackey versus Texas in the Supreme Court. And I had to go find original sources to show what the people who educated the people who wrote our Constitution thought about the death penalty. So, the the English law sources, that the original English law sources. And then I worked with barristers in that matter, but also in the research of the case, but also got to know them and realized, wow, these are some very impressive lawyers. Now, not all of them, just like in any situation, there can be people who maybe have the title but don't have the substance. But in my experience, the vast majority of barristers I've dealt with many over the years, very good, very smart, very hardworking. So I worked with them initially in death penalty cases, and then in the last few years I have been an expert witness in English extradition proceedings where the United States government's trying to extradite a person who has been charged in federal court in the United States who's been arrested in the UK. So I am called to testify about what kind of sentence they likely will get if they come to this country, and these are all non-death penalty cases, and what American prison conditions are like. So I have repeatedly, over the last few years, testified in these extradition proceedings, which interestingly occur in magistrates' court. They're not like in the higher courts in England, but I found the magistrates very competent over there. And the barristers are the ones who represent the person, they call them the interested person, interested person, I forget the exact name, but it's the person who's sought to be extradited. So it's barristers representing those people. And so I have dealt with barristers over the years. And the thing about barristers in England is they both prosecute and defend, traditionally. They both prosecute and defend. They are appointed to prosecute, they are appointed to defend. I wish we had that in our country. One of our problems is our prosecutors are in silos. They often stick to that their entire career. And defense lawyers are in silos. They either never became a prosecutor or they were only a prosecutor for a short amount of time and then became a defense lawyer. So we don't have perspectives, dual perspectives. And when you actually have to 1 week prosecute and 1 week defend, I think you're much more likely going to be more fair as a prosecutor. If you're a career prosecutor, you are going to get career promotions, right? You're going to get prosecutor of the year or promoted to the next level of pay or made the head of the office or head of the appellate division or whatever, based on your positive performance. How do we gauge prosecutors' performances? Convictions. I don't know any prosecutor who gets a promotion because they got a not guilty, they lost, and they go back to the office and the boss says, congratulations, you did such a great job getting a not guilty for this defendant. You don't do that, right? So if you are a prosecutor who also the next week is defending and then maybe the next week is prosecuting, you're not in that silo of this is all I do and the only way I'm ever going to get promoted is to win cases, and to win cases means to get convictions. So that's something I wish we did more of here, is not just have this being in a silo, which happens too often.
Professor, continuing this discussion, how do you think these differences create some challenges in cross-border matters, and how do you think these challenges can be applied? Is there any challenge that can arise because of these differences?
Oh, of course. Yeah, I mean, the vocabulary and culture, even, the English system, my ancestors are almost all from England, Scotland, Wales, Ireland, right? I speak English. I love English history, but there's still a breakdown in communication every time I testify because we just have differences, right? And if that's true between the American system and the British system, imagine it being the American system and the French system, or the Armenian system and the Russian system, or the South African system. It's very hard to have meaningful dialogue between two different systems when you don't work together on a regular basis and don't know the other systems. I'll give you a great example. So when I was at the U.S. Sentencing Commission, I was deputy director for a decade of the Sentencing Commission, and we would have foreign delegations come to study our sentencing guideline system and often not follow it, but they wanted to at least learn about it. And one time, I was not there. This is a story I've heard from other people, but I don't think it's apocryphal. I think it's true. One time a Russian delegation came and we showed them our sentencing guideline table, which if you look at the federal sentencing guideline table, it is broken down into months. So 0 to 6 and 3 to 9 and 6 to 12. These are in months. They go up to 360 months to life or whatever, but it's a table of months, ranges of months. And these Russian judges and lawyers and prosecutors came over, and we put the table up on the PowerPoint, and they looked at it, and they were like, I like it. They were thinking it was years. There's always going to be breakdown in communications when you don't have enough of a shared dialogue, and we don't. Our country is, I mean, the UN is not working. We don't have enough common legal systems. We don't share enough. We don't respect each other's countries, I think, enough to have good dialogue.
Actually, that was something that I would like to ask you about. For countries like Armenia or other countries that are continuing to develop and refine their legal systems, which aspects of the US legal system do you think is worth adopting, and which aspects should be taken more carefully?
Judicial education. We have a wonderful judicial education system, at least in our federal system. Some of the states do too. We have the judicial, we have the Federal Judicial Center, which is the FJC, which is the part of the federal court system that educates judges. So initial education when they first get on the bench, and then continuing education. And there are resources, and they have all these wonderful classes and treatises that judges have access to. So judicial education. A public defender system. If you're going to have criminal prosecutions and people cannot afford lawyers, they need to have good, competent lawyers. Our federal public defender system is superb because it's well funded and well respected. So those are just two ideas. If I were building a system from scratch, good judicial education, the Federal Judicial Center of the United States is a great model, and a good public defender system in criminal cases, the federal public defender system is a really good model. But there are other things I could get into, but those two come to mind initially.
Now, last question before we close it out. I know that you pride yourself on being a generalist, which is a dying breed. So what legal advice do you have for students who want to build a career and be a generalist like you? How do you get experiences in civil and criminal, in prosecution and defense?
So I started I went to law school thinking I was going to do international human rights law, which kind of can mix both civil and criminal. Eventually, quickly turned into a criminal defense lawyer, became a public defender. But I knew as a public defender, started out with death penalty cases, eventually got to non-capital cases. I knew I wanted to eventually practice civil and criminal law. So I started as an adjunct professor in the year 2000, teaching remedies. And I really, I kind of felt like an imposter, because who was I? A, I was 30 years old. B, I'd never really practiced civil law other than a little bit as a law clerk for a judge. But I basically just learned it as I went, and I taught it semester after semester. And then I eventually taught civil procedure and other civil courses. I've taught contracts, I've taught conflict of laws, a lot of professional responsibility is civil more than criminal. I did the teaching part while I was a practicing criminal lawyer, knowing that down the road I wanted to do both. And then I slowly started getting into civil cases and working with other lawyers much more experienced than me. And I also think it's very important you do appellate work as well as trial work. They complement each other. I like practicing in state court as well as in federal court. You also, to be a good lawyer, you've got to have a passion for lifelong learning. And if you don't, just pick yourself a specialty and do that as your only thing. To be a generalist, you've got to have a passion for lifelong learning.
That was going to be my next question, Professor. I ask all my guests this question to give my audience a better understanding of the legal profession in practice, and I wonder, how do you manage balancing your work as both practitioner and a lecturer in this demanding field?
Every morning that I wake up, 95% of the mornings I wake up that I have work that day, I look forward to it. Sure, nothing's perfect. There are parts of my job I dislike. Everybody dislikes parts of their jobs. But the intellectual engagement, whether I'm working, right now I have a civil appeal about a dismissal of a complaint under Rule 9b because it allegedly didn't plead, or supposedly didn't plead fraud with enough particularity, right? So I've got that. And then I have pending death penalty cases where I'm moving to strike the death penalty based on various issues, just a wide variety. So it's kind of like being a law student, right? You take contracts, then you go to Crim Pro, then you go to Civ Pro, then you go to property law, right? I found that engaging. In law school, I loved all these different things. And what I really loved was trying to find this, what Oliver Wendell Holmes called the seamless web of law, the thread that really ties it all together. And being able to use issues in one area to your advantage as an advocate in another area has been one of my, I think, things that I really enjoy doing. So I love speaking civil law talk to criminal law judges and vice versa, especially at the appellate level. They appreciate that.
Thank you so much, Professor. Thank you for taking time. This was a very insightful and engaging conversation. We really appreciate it. And thank you to our listeners for joining us on Tatev Talks Law. I look forward to seeing you in the next one.